Welcome back to Law Talk. My name is Chris White. I'm an attorney in Fresno. I do accidents and injuries, immigration and DUIs. And today we're talking about collaborative divorce or collaborative law. And our guest today, we're honored to have Sausan A. Thank you very much for coming on.
Thank you for having me.
All right. Now, when I think of divorce, I think of contentious litigation, very expensive, everybody very upset, high stress. What is there? I thought that's just the way it was. Is there a better way to do it?
It can be very high, very stressful, very contentious, and unless you choose to make it otherwise, it can be. But there is another way, and there's a better way to do it, and it's called collaborative law.
Is that a new thing, or has that been around for a while?
Actually, it's been around for about the last 40 years. There's an international association of collaborative professionals. It's in almost every country in the world, but we are just starting to present it here in the Valley.
Okay. So the judges in Fresno all know what this is and recognize it. Do they ever tell people, maybe you should try this? They send people off to mediation.
True.
Is collaborative law sort of like a different kind of mediation, or what's the difference between the two?
Collaborative law actually starts out with the parties choosing to participate in a process called collaboration. Okay. So when they choose to participate in the process called collaboration, they could have already started it via litigation, but instead they're realizing that they can make a lot of these decisions without the help of the court. And so if they can make these decisions without the help of the court, but with the assistance of attorneys, with the assistance of divorce coaches, and financial neutral, and a mediator known as a child specialist, they can reach better decisions than what a court would order them to do.
Sounds like a good idea. It sounds like a lot of people. Is it more expensive to do it in collaborative law or the litigation or traditional ways, or it depends?
It depends. As sounds like coming from a lawyer, though, too. It's always,
yeah,
it
course.
Depends. But here's the issue. Once you get into litigation, typically then you go to mediation. From there, they can send you out to a psychologist. Psychologist to do a psychological evaluation ends up about $5,000 to $7,000. Plus, you're each seeing your own counselors, because divorces are like major medical issues to people. You're tearing people's lives apart.
Yeah.
And so you need someone. So now you're paying for a counselor on the side. You're paying for the psychological evaluation. You each are paying for someone to handle your financial issues. So by the time you're done, I had one case that turned out for a child custody to be $35,000 just for child custody.
That's crazy.
So
what if you only have $2,000 each?
Well, if you only had $2,000 each, that would be spread amongst the 4 core team members, which is 2 attorneys and 2 divorce coaches. What I've discovered in doing collaborative law is that my role now becomes that of an attorney counselor versus an attorney psychologist. Because you see, now you have the divorce coach who's trained to help people deal with their emotional issues. I don't have to anymore. So they're paying less fees for that divorce coach, because typically they're at least half to 3/4 of mine.
So what's the attorney's cost for family law now? Like $250, $300, $275?
$250 to $300 an hour.
Okay.
And a divorce coach is going to be typically about $120 to $125 an hour.
As opposed to like a psychologist or a psychiatrist, where it's like
Actually, our divorce coaches, the majority in the Central Valley Collaborative Law Affiliate Group, are all psychologists or psychiatrists. So they have an extensive amount of training in their own field, plus they've chosen to go and take extensive training to become collaborative professionals and divorce coaches.
Okay. So I'm trying to think practically how this works. So am I right in saying the only way that it really works is if you choose an attorney that believes in collaborative divorce, and your spouse chooses an attorney that believes in collaborative divorce, because everybody's got to agree to it going in.
That's correct. And if I have a client who comes in and says, I would like to do the collaborative process for my divorce, what I routinely do is, if I find out that there is no attorney for the other person or the other party, I will send them a letter letting them know that their spouse would like to proceed without court intervention. Here's what we're offering. I send them information about it, and then I give them a list of the attorneys that they can go and talk to.
Okay.
And I can tell you, for the majority of the attorneys in our group, we decrease the amount that we would charge for an initial consultation if we know that it's going for a collaborative case.
Oh, really?
Yes.
Does that go the same for the retainer maybe too? Or no?
Sometimes, yes.
Sometimes. Okay. So, are there some attorneys in town that when you have a potential client come in and they say who's on the other side, you know immediately this collaborative thing is not going to work because based on the attorney that they choose? Somebody told me one time that like you can almost see the way the divorce is going to go just based on which two attorneys are on the other sides.
I've actually had one where the other party canceled their attorney that was non-collaborative, and they chose to go in with the collaborative process, and they went and picked a completely different attorney.
Really? Wow.
But what we also did too is we had both of the parties go and meet with divorce coaches and let the divorce coaches explain how it would be better for them to go through on the collaborative. And so we used the mental health professionals to help get the parties into the collaborative process, and it was very successful.
So if you got one person that has a pretty good idea that they want to do collaborative law, and the other person has a pretty good idea that maybe they don't want to do it that way for whatever reason, I don't know why, then one way to possibly move it into the collaborative process is to have like a consultation with one of the coaches beforehand.
Correct. Or even after they've chosen. Sometimes folks don't understand what the collaborative process is really about, and they want to go to that attorney who's going to go fight for them. I'm going to get my rights. I'm going to get what I want.
Yeah, everybody wants the attorney with the boxing gloves on that's going to get them the better deal.
And what they don't realize is the better deal is all in the mind of that attorney, and it may not be even what they want.
Oh.
But they're letting someone else drive the bus for them, and that's not fair.
It's unusual to hear another attorney talking about like that about their colleagues, but I guess we all think the same things maybe, but we don't always say it. You mean like it's possible that there might be some divorce attorneys out there that might prolong the litigation process in order to get more fees?
Absolutely.
Well, how do you make sure that you don't end up with somebody like that?
It takes a lot of work on the other attorney's part if they realize that they're dealing with an attorney who wants to proceed in that manner. And it's a constant having to find all the information, make sure that it's on the table, get it said, and move it towards the process of letting the court conclude the issues. And I can tell you that the majority of our judges now want parties to reach an agreement themselves versus the court placing a finality on it, because what the court's discovered is that if the parties make an agreement themselves, they're more likely to live with it than if the court mandates it. That's when it gets the fight even more.
And they won't keep on coming back with some dispute about that the judge ordered. I mean, that's kind of the judge. In my knowledge of the divorce court system, I always figured that was the judge's job was to impose a settlement on people who just can't figure it out amongst themselves eventually.
Correct.
And no, but then everybody loses. Well, sometimes you win and sometimes you lose, but everybody walks away unhappy normally.
That's right.
And then the collaborative process might be a way to figure out a way that some things may not be so important to one person, but really important to the other, and that's how you divide things up. What was
and
that?
that's the divorce coach comes in and helps the parties understand what their underlying goals are, what it is that is of interest to them, and what they want to accomplish in taking apart this relationship. If, for instance, I use the analogy of an orange. the court, by law, has to divide things on a 50% basis after there's been an equalization of the assets and the debts. So, for instance, the court would take an orange and just cut it right in half. The issue is, though, is that, for instance, you may want all of the orange juice, and your former spouse could use the peel to make potpourri. Well, if you cut it in half, you've now just been deprived of that one half of the orange juice, and your spouse has just been deprived of your one half of all the peel.
It's almost wasteful.
It is, because now you're going to throw away one part of it, they're going to throw away one part of it, or they're going to get hit with taxes. You're going to get hit with taxes. That, you see, if you're trying to negotiate in the hallway of a courtroom, you can't go and talk to a tax professional and say, what happens if I get this amount of money, but she takes it out of this 401k? Is she going to get hit with more taxes, and am I going to come out with less? How do we equalize that?
So it's some more planning.
That's correct.
If you're fighting less and planning more, maybe you end up with a better deal at the end.
You actually end up with a better deal. I have a case that's in progress right now in the collaborative where the husband has realized that if the wife takes one of the large assets, that she's going to get hit with taxes. So he has asked the financial professional to please reallocate so that the taxes are offset as to her. But this was something, because she wasn't financially savvy, that she would have never known but for the fact that we have a financial person and the husband who can say, let's help figure out to make sure that wife doesn't end up shorted.
Yeah, you would think that her attorney would tell her that, or at least know to have her talk to a tax person. But
I can tell you the majority of attorneys, and I don't mean this in a disrespectful manner at all, but it's not something that you can present to a person when they're under the angst of having to make a decision in the courtroom hallway.
Right. Right. Wow. Well, I'm impressed about the collaborative law. I mean, what's the downside? Why would you not want to do it? I hear that, like, if you have an attorney and you go into collaborative and it doesn't work, and then you got to go litigation route, then you both got to get new attorneys.
That's correct.
Are there any other downsides to collaborative?
Well, we're still working on the process of how to deal with, for instance, if there's been any kind of domestic violence that occurs in a relationship, and if there has been those kinds of acts, how we would set up the collaborative process to allow these parties to conclude the division of their assets. I do know that in Texas and Wisconsin and in Canada, they are having some great success with handling these kinds of cases that have involved domestic violence. Here in California, we have not completely solidified that yet as to how we would handle that. So for right now, those are cases that would not be, what shall I say, qualified for the collaborative because of the potential for harm or danger to either one of the parties. So
I could see that. And I guess the attorneys that are involved in the process pick and choose which cases they're going to put into the collaborative as opposed to which ones they're not. Or maybe there may be some that they look at and they know it's not going to be
that is
collaborative.
Correct. We do. And we have constant training. Every month we've got a training going on, doing an intake and being sure that people understand what they're getting involved with and how they're going to work through this. I can tell you that certain folks with, for instance, like bipolar or some of these other maybe large or small mental health issues are really qualified for collaborative because it keeps them out of the limelight of the court.
Okay.
And by that I mean is when you're in the courtroom and you start arguing over, for instance, who has custody of the children, and if there's mental health issues that start coming up, that could really affect someone's job if that comes out and is now written in a court document because it's public record. You don't want that out there in the public.
Well, one spouse might, the other one may not.
Right.
You know how people are.
That's right. They might want to have a vendetta. But collaborative allows it to be contained, so those things can be dealt with, and we can work with the outside professionals to make sure that everyone's protected, including the person that has the specific issue, because there's nothing wrong with that person, but it can be used as a weapon by the other party in a courtroom. And that's not something you want when you're going to have to see your kids someday at weddings, graduation
people are
from
thinking
high school.
that far ahead. Yeah, one day the kids will find out what really happened, or why. Yeah, who knows? But I would think that one of the main selling points for collaborative law, and we're running out of time here, so we kind of got to wrap up, would be that it's perhaps better for the children if the parents aren't going through a prolonged litigious divorce process. Is that
Absolutely.
true? Yeah. So if for no
Absolutely.
other reason, you might do it for the sake of your kids, if this might be a way to come to an agreement that everybody's going to stick to, as opposed to keep on coming down to court for the next 5 or 10 years and asking the kids which parent they want to stay with, or
Correct.
something like that.
That's
Yeah.
right.
All right. Well, thank you very much for coming on, Susan. How do people get a hold of you? What's the best way?
They can find me either at my website, which is www.hemlawgroup.com, or my phone number, 559-241-7050.
That sounds fantastic. And I heard there was somebody, we were talking about something about maybe having a whole show devoted to collaborative law and maybe having a couple of other attorneys in your group. Is that something that you're thinking about doing, or you might want to do?
Absolutely.
Okay,
Yes.
so look out, and maybe the next couple of Fridays, maybe 2 or 3 Fridays from now, we'll have some other attorneys that are in your collaborative law practice group and go into some more detail about some of the things we were talking about. If you can find us on Facebook, Law Talk. You can look up Law Talk, Chris White, Fresno, and you can send in some questions that you might have for Susan, or some topics that you might want to see addressed. If they have a discussion, maybe a panel of 3 or 4 collaborative divorce attorneys talking about the different more details about what can be accomplished through the collaborative law practice rather than the litigation process. Well, we will be